Hello viewers, welcome to the course on jurisprudence. I am Dr. Simranjeet Kaur Gill, Professor of Law, City University, Ludhiana. Today we will discuss the important topic of the definition and scope of jurisprudence. So let's start our voyage to decipher the topic with the introduction of the jurisprudence. So in this topic we will be discussing the meaning of the jurisprudence. Jurisprudence allows us to grasp and more abstract nature of the law. Jurisprudence is an important part of the law that is based on the different hypotheses and interpretations. Jurisprudence speaks of the relationship between the law, culture, man, nature and other social sciences. Jurisprudence denotes a logical and analytical study of the law. The term jurisprudence originated from the Latin word juris and prudentia, meaning knowledge of the law, which can be divided into two sections, and that's the jurisprudence that originated from the word jus meaning law and the word prudential meaning prudence. For thought or discretion, jurisprudence can also be referred to as a legal philosophy. Jurisprudence offers us an outline and a much deeper understanding of the law and the role of law plays in the society. It deals with the legal logic, bodies of law and legal frameworks. So when we discuss the definitions by the different philosophers, what Austin talks about it, Austin calls the jurisprudence the philosophy of the positive laws. By the positive law or the positivism, he means that the law made by political superior to control the behavior of those who are under his authority. Therefore, the positive law used by the Austin is identical to civil law. The term philosophy is used by Austin to describe jurisprudence in somewhat miserable way. The first jurist to make jurisprudence a science was John Austin, who is often considered the father of English jurisprudence. With the analysis of its underlying concepts of the principle, Austin defines jurisprudence as a science of law, concerned with the analysis of its underlying the concept of principles. For Austin, the relevant subject of jurisprudence is positive law, that is law as it is. For him, jurisprudence was not a moral philosophy but a systematic study of the real laws as opposed to the morals, ideals or the natural laws. Austin further divides case precedent into two categories, that's journal and specific jurisprudence. If we talk about journal jurisprudence, according to Austin, journal jurisprudence is the philosophy of the positive law. They are directly related to the principles and differences common to the various active and specific legal system. And each of these different systems certainly implies its meaning. Is it worthy of praise or blame, or whether it conforms to an assurance, measure or test. For Austin, therefore, jurisprudence generally means the science concerned with exposing the principles, concepts and differences common to different legal systems. Concepts of rights and obligations, property, possession, personality, etc. of the journal case. Common precedent is an attempt to set out basic principles and journalize the dissemination of two or more systems. If we talk about particular jurisprudence, it is the study of law as the science of a positive legal system as it currently exists on a real system that exists in a particular identified country or defined countries. Specific determination according to Austin jurisprudence is specifically the science of any real system of law or any part thereof. The actual jurisprudence is concrete. The Austin jurisprudence classification in journal and in particular has been criticized by the Salmond, Holland and other jurists. Salmond points out that flaw in the Austin's idea of the jurisprudence in the journal lies in his assumption that unless a legal principle is common to many legal systems, it cannot be handled in journal jurisprudence. There may be many of the schools of jurisprudence, but there are not many different types of jurisprudence. Jurisprudence is an inseparable social science. The distinction between journal jurisprudence and specific case precedent is inappropriate. It is not connected to use terms such as Hindu jurisprudence, Roman jurisprudence or English jurisprudence. Jurisprudence is a social science that deals with the social institutions governed by the law. The jurists of the historical school have also denied the existence of jurisprudence in journal. As a rule, like language grows and develops, in this evolution, it is jurists of the historical school who also denied the existence of jurisprudence in journal. According to the law, like the language grows and develops, in this evolution, it is regulated by local factors, for example, political, geographical, religious, historical, etc. These local factors vary from one country to another. As these local factors vary from country to country, only specific jurisprudence can be obtained. Holland is consistent with his definition of jurisprudence as a science which rejects the distinction between law, jurisprudence in journal and jurisprudence in particular. He said that if jurisprudence is rightly called a science like all other sciences, it must be journal and it makes no sense to call it specific. He further emphasizes and illustrates his point with examples from geology. Geology is the science of the composition and structure of the earth. Would be strange use of language to call the study of Britain's composition and structure a geosciences. Gray accepts Austin's classification of jurisprudence into journal and particular jurisprudence, though he prefers the term comparative jurisprudence in place of journal jurisprudence. Allen also agrees with Austin. He says there are certain elements inherent in the conception of law as a phenomenon of social life. Therefore, existence of journal jurisprudence is possible. Now, we will discuss the Holland's definition. Holland has defined the jurisprudence as the formal science of positive law, specifies but with the basic fundamentals. Jurisprudence from this point of view should relate to the journal part of legal doctrine. It must deal with the journal concepts and universal principles which form the basis of any comprehensive legal system. Thus, jurisprudence began to be understood as a scientific study of fundamental principles, the basic of many developed legal systems. Austin's analytical approach to the study of law was continued by Thomas Erskine, Holland and other English jurists. He has described the jurisprudence as the formal science of ordinary human relations, recognized as having legal consequences. The formal science of the positive law, Holland, the six-word definition of jurisprudence is flawless. Formal science of positive law. The question is, what is formal science? Holland herself explained in the primary terms. Human relations are governed by the rules of law rather than by substantive rules which in and of themselves have later been interrupted. In a feminine sense, like Austin, it is a present and existing law as opposed to the hypothetical, ideal and abstract law. Salmond's definition, Salmon defines jurisprudence as the science of the first principles of civil law. He therefore emphasizes that jurisprudence deals with a particular type of law. For example, civil law or a state law. Civil law is made up of rules applied by the courts in the administration of justice. He agrees with the Gray in arguing that jurisprudence concerns only the law of jurists and not the law of theologians and moralists, although they also govern human behavior in the society. According to Salmon, jurisprudence in the specific sense includes theoretical precedent. Therefore, it does not deal with specifics but with its basic principles and conceptions. Journal jurisprudence, in Salmon's view, is not connected with the study of the legal system in journal, but with the journal and basic elements of a particular legal system. In addition, Salmon divided case precedent into the following categories. Law exposure. Its purpose is to expose the content of a real legal system as it has been, whether formally or here. Legal history. Its purpose is to expose the historical process by which any legal system has become or what it is. The science of legislation. Its purpose is to state the law, not as it is or ever existed, but as it should be. It is not concerned with the past or present of a legal system, but with its ideal future. It further divides case precedent in a specific sense into law analysis. The aim is to analyze without reference to their historical origin or development, their moral significance or validity. First principle of law. Law history, if we talk about the same, aim is to address the general principles governing the origin and development of the law. Is the history of the formation of the first principles and conceptions of the legal system. If we talk about the ethical rights, the aim is to deal with the law from the point of view of its moral significance and completeness. It is not about the intellectual content of the legal system or its historical development, but the purpose of its existence and the means and the ways of achieving it. According to Salmon, adequate scientific treatment of any body of law involves the study of these categories of jurisprudence. Salmon's definition has been criticized on the ground that it narrows the scope of jurisprudence by saying that it is a science of civil law and therefore covers only particular legal system. With the advent of a functional approach, the province or scope of jurisprudence could not be limited. The study of jurisprudence is not limited to the study of the law administered by the courts of law. It also notes the realities of the social life of societies. If we talk about Keaton, Keaton defines jurisprudence as the study and the systematic arrangement of the general principles of law. Dean Roscoe defines jurisprudence as the science of law, using the term law in the juridical science as denoting the body of the principles recognized or enforced by the public and regular tribunals in the administration of justice. Dr. Casey Allen, jurisprudence is the scientific synthesis of all the principles of law. According to G.W. Patton, jurisprudence is a particular method of the study, not the law of one country, but of the general notion of law itself. If we talk about Julius Stone, he described jurisprudence is the lawyer's extroversion. It's lawyers' examination of the precepts, ideals, techniques of the law in the light derived from the present knowledge in discipline other than the law. What Gray talks about the jurisprudence? According to John Chipman Gray, jurisprudence is the science of law, the statement and systematic arrangement of the rules followed by the court and principles involved in those rules. Alpine has also specified what he thinks about jurisprudence. According to Alpine, who was a Roman jurist, he defines jurisprudence is a knowledge of things, divine and human, the science of just and unjust. Miss Dias, the study of jurisprudence is an opportunity for the lawyers to bring the theory and life into focus, for it concerns human thought in relation to the social existence. H.L.A. Hart talks about a legal system consists of primary and secondary rules. These rules explain the nature of law and provides key to the science of jurisprudence. He viewed jurisprudence as a science of law in a broader perspective by correlating law and morality. From the above definitions of the jurisprudence, it could be seen that there is no commonly agreed definition of the jurisprudence. Each jurist guided by his own conscience, but the science, the conception of the term law till the beginning of the 20th century, a new approach to the study of law in relation to society is given. Some jurists, therefore, treat law as a social engineering, an instrument to bring the social change. The function of law is to supplement to the social sciences. If we talk about the nature of the jurisprudence, jurisprudence in its nature is entirely a different subject from other social sciences. The reason for that is that's not codified but a growing and dynamic subject having no limitation itself. Jurisprudence has no limited scope. Being a growing subject, there is a difference of opinion about the nature of the jurisprudence as well. It is called both art and science, but to call it science would be more proper and useful. The reason for this is that just as in science, we draw conclusions after making a systematic study by inventing new methods, similarly, jurisprudence is concerned with the fundamental principles of law and systematic studies of their methods. Jurisprudence studies legal concepts and tries to find out the essential principles of law. If we talk about its scope, so there is no unanimity of the opinion regarding the scope of the jurisprudence. It may be discussed under the following three heads. The first one is early period. In the early period, jurisprudence has been so defined as to cover moral and religious precepts also, and that has created confusion. Second is Austinian period. It was the Austin who distinguished law from morality and theology and restricted the term to the body of rules set and enforced by the sovereign or the supreme law-making authority within the realm. So, the scope of the jurisprudence was limited to the study of the concept of positive law only. If we talk about modern period, at present there is a tendency to widen the scope of the jurisprudence. The present view is that the scope of jurisprudence cannot be circumscribed or limited. It includes all the concepts of human order and human conduct in state and society. Importance and utility of jurisprudence is basically a theoretical subject, but it also has a practical and educational value. The practical value or the purpose of jurisprudence has been enumerated as under. The first one is remove the complexities of law. One of the tasks of the jurisprudence to construct concepts and make law more manageable and rational. Answer the new problems. This is very important that jurisprudence can teach people to look around them and realize that answer to the new legal problems must be found by the consideration of the present social needs and not in the wisdom of the past. If we talk about grammar of law, jurisprudence is actually a grammar of law. It throws the light on the basic ideas and the fundamental principles of law. For example, negligence, liability, etc. So, if we talk about training of mind, jurisprudence trains the mind to solve the difficult legal provisions in the legal way. Grasp on the subject. It helps in knowing and grasping the language, grammar, the basis of the treatment and assumptions upon which subject rests. Useful in art of pleading and legislation. It helps legislations and the lawyers the proper use of legal terminology, for example, right, duty, etc., to interpret the law. It helps the judges and the lawyers in ascertaining the true meanings of the law passed by the legislature by providing the rules of interpretation. To study foreign law, it enables lawyers to study foreign law because the fundamental principles are generally common to all systems of law. Importance under the light of different jurists. Significance and need of the study of jurisprudence. This subject has its own interest and value because this is a subject of research. Researchers in jurisprudence contribute to the development of the society by having the repercussions in the whole legal, political and social school of thoughts. One of the tasks of this subject is to construct and elucidate concepts serving to render the complexities of the law more manageable and more rational. It is the belief of this subject that theory can help to improve practice. Jurisprudence also has an educational value. It helps in the logical analysis of the legal concept and it sharpens the logical techniques of the lawyer. The study of the jurisprudence helps to put law in a proper context by considering the needs of the society and by taking the note of the advances in relation to the relevant disciplines. Jurisprudence can teach the people to look, if not forward, at least sideways and around them and realize that answer to a new legal problem must be found by the consideration of the present social needs and not in the wisdom of past. Jurisprudence is the eye of law and the grammar of the law because it throws light on the basic ideas and fundamental principle of law. Therefore, by understanding the nature of law, its concept and distinctions, a lawyer can find out the actual rule of law. It also helps in knowing the language, grammar, the basis of treatment and assumptions upon which the subject rests. Therefore, some logical training is necessary for a lawyer which he can find from the study of jurisprudence. It trains the critical faculties of the mind of the students so that they can dictate felices and use accurate legal terminology and expression. It helps a lawyer in his practical work. A lawyer always has to tackle new problems every day. This he can handle through his knowledge of jurisprudence, which trains his mind to find alternative legal challenges of thought. Jurisprudence helps the judges and lawyers in ascertaining the true meaning of the law passed by the legislations by providing the rules of interpretation. Therefore, the study of jurisprudence should not be confined to the study of positive law, but also includes normative study. That is, the study should also deal with the improvement of law in the context of prevailing socio-economic and political philosophers of time, place and circumstances. On the concluding remarks, jurisprudence is the bundle of different legal provision. It is the study of the law, and the law is controlling machine for the society. Law is the instrument of justice for the society, because law is the basic requirement of the society. If we will not study jurisprudence, we will never understand the meaning of law. We study the basic principles of law in jurisprudence. So, we can say that jurisprudence has great educational value. Though several thinkers have questioned the utility of jurisprudence, it still remains one of the most important subjects of the law. The purpose of the law is to regulate society, to maintain order. Jurisprudence ensures that law remains connected with the society and its philosophies. This was all for today. Thank you for watching the program.